Hello, my name is Joe Freed. I'm an attorney who specializes in handling cases involving truck crashes around the country. I've been teaching other lawyers about the best practices and about how to handle these cases for well over a decade now. And so I'm kind of become known around the country as the go-to guy to answer questions. And one of the biggest questions I get, and I get these calls literally every day, are from lawyers across the country having to do with when truck drivers are required to be drug and alcohol tested after a crash, and what happens if they're required to be tested but they aren't tested. How does that work? And so I figured I'd put a quick video together to explain this. So here's the ground rules. Number one, after a crash, a truck driver who has a CDL license, this does not apply to drivers who don't have CDL licenses. If you have a CDL license, you're involved in a crash, you're required to be drug and alcohol tested, both, not one, both, drug and alcohol testing, in one of two situations. Either there's a fatality, and if there is, it doesn't matter who's at fault, testing has to occur. And the second situation is if there's an injury or a tow away from the scene, and the driver themselves, the truck driver, the commercial driver, is being cited by law enforcement. Those are the two times when testing is required. And the regulations put that duty both on the driver and on trucking companies. So companies have to make sure that their drivers get tested in that situation. But what happens when somebody drops the ball, either on purpose or not on purpose? Well, we oftentimes don't know if it's on purpose, right? So the law is written in a way where if you don't do what you're supposed to do, and as a result of that, evidence that might be used against you is destroyed, or what the law calls spoliated, then what can happen is a judge, if they hear the facts and they agree that there's a good enough reason to do this, what the judge will do is issue an instruction to the jury that is called a presumption charge. And what the judge says is, ladies and gentlemen of the jury, because this was required to be done and it wasn't done, you can presume that if that test was done, it would have been harmful to the truck driver and the trucking company. Now, that's a rebuttable presumption, which means that it's not established as a matter of law that somebody was drunk, intoxicated, high, or whatever. It's just it's a rebuttable presumption. So other evidence comes into play, but the jury is authorized, based on that spoliation charge, to conclude that the truck driver was under the influence. What happens in the real world in those situations is the other evidence becomes very important, because if all you have is a test that wasn't done, but nobody at the scene and the facts of the crash are not the kind of thing that make you say, gee, that truck driver must have been drunk or high, then oftentimes the presumption gets rebutted. So what I tell lawyers across the country is, it's bad when it happens, but you have to look at the rest of the facts. Are the police officers who were at the scene going to say, yeah, there's some indication that the driver was acting in a strange way that's consistent with being intoxicated? Are the facts of the crash of the sort that happen more frequently when people are drunk or intoxicated or high? And you get the point. So when it happens, truck drivers and trucking companies get put under a microscope for why it happened. Why did the test not happen in time? And depending on the outcome, you can find yourself in a really bad situation at a trial with a judge telling the jury, presume that that truck driver was intoxicated. Presume that that truck driver was high. That's the way it works.